Great, thank you, Michelle. And I'm now back for my second of two presentations this morning. This one is about frustration of employment contracts due to disability. And we will look at one of the cases that we will look at in this presentation is called Roskaft and RONA Inc, which is a 2018 decision, so pretty recent. Oh, we're going the wrong way here. Let's move forward. Okay, so before we get down to it, so what is frustration of contract? Okay, so frustration of contract occurs when subsequent to the formation of a contract, an unforeseen event or circumstance results in the obligations of the contract being radically different from those contemplated at the time of the formation of the contract. So the change in circumstances needs to be unforeseeable and has to have occurred through no fault of either party. Frustration of contract is typically associated with an inability to perform the original contract. And I'll take you back to the 1863 decision of Taylor and Caldwell for a little bit here. This was a very early example of frustration of contract. There was a contract between two parties to rent out a music hall for a concert. After the contract was entered into, but prior to the concert date, the hall unfortunately burnt down in a big fire, and the court in that case ultimately said, well, then this contract is frustrated. Neither party has any obligation under it anymore because it effectively is impossible to perform because there is no more music hall. Okay? There's some other examples of frustration that we can get into. The relevant one for this presentation is when we have an employee who is unable to work due to injury or illness. And I'll just add that in order for the contract to be frustrated, this does have to be the case for the reasonably foreseeable future. That's the language that's been used by the courts. Okay, so here's a nice quote from a 2011 decision called Frazier. Frustration is established if, at the time of termination, there is no reasonable likelihood of the employee being able to return to work within a reasonable time. Okay, that's a pretty good summary. Okay, so when we're dealing with frustration of contract due to a disability, the court effectively has to find that this is a permanent disability that will result in the employee not being able to return to work. Okay, and the courts are going to look at the facts of the particular case and will make a decision in that regard. So some of the factors that the courts will look at are, first of all, the nature and expected length of the illness. Okay, so is the employee likely to just need to be off work for a few weeks or a couple of months, or does this employee need a long time, more than a year, maybe even more than 2 years to recover? What is the employee's prospect of recovery, or in other words, what is the employee's prognosis? Okay, the length of service of the employee also matters, in that usually when you're dealing with a long service employee, it's harder to get the employment contract to be found to have been frustrated more quickly. So put another way, the longer the length of service of the employee, generally speaking, the longer period it's going to be that needs to have elapsed before the court will find that the contract has been frustrated. And I'll just mention one more factor that's also important in addition to these three, and that is the employee's role or position at the company. Okay, so if you're dealing with a senior executive who becomes ill and is maybe only off, for a relatively short period of time that can be measured in weeks or months, that might be enough to frustrate the contract if you're dealing with someone who's that senior, who might be that important in the day-to-day operations of the company. On the other hand, if you're dealing with someone like a more administrative or clerical type employee who is, not quite as important as the senior executive in the day-to-day decision-making of the company, then that would suggest that a longer period of time needs to go by before that contract will have been frustrated. Okay? The burden of establishing that an employment contract has been frustrated is on the party who wants to rely on the principle, right? So normally, it's going to be an employer who is going to take the position that the employee's contract has been frustrated because they've been off sick for a while, they're not coming back anytime soon, and the employer wants to move on, end the contract, and quite possibly hire another employee, okay? So normally it's going to be the employer who says this contract has been frustrated, so the employer would then have the burden of proof. Now, as we'll get to a little bit later on, employees can also allege frustration, okay, and we'll see why later on. I mean, the preview is that it relates to their minimum statutory entitlements under the ESA, and we'll look at a case called the estate of Christian Drimba in that regard, okay? So, if the court agrees that an employee's contract has been frustrated, how does that practically affect an employee? Well, they don't have a job anymore, they're probably still ill, and they're probably not going to find another job anytime soon. So because these are fairly harsh consequences that would occur to an employee, the courts are going to look carefully at the relevant facts before making a finding of frustration. Okay? So what happens if a contract is frustrated due to disability? Okay, so the starting point, we go back to the Taylor case, the old 1800s case there. Starting point is, well, neither party will have any obligations to each other anymore pursuant to that contract. So yes, it does mean that the employer no longer has to provide a common law notice period to the employee. Okay, but in the employment context, now we have to look more specifically at the language of the Employment Standards Act and of the relevant regulation. So essentially, the result is that if an employment contract is frustrated because of illness or injury, the employee is still entitled to their minimum ESA entitlements, so that being the termination pay and the severance pay. Okay, so on the next couple of slides here, we really just reproduced the text here from the regulation in which this is set out. You don't really need to read it all, but that's effectively what it says. Okay? So now we'll get into some cases here. Okay, so the case of Nacarado and Costco was decided back in 2010. I'm not going to go through all the facts here. I mean, we have talked about this case in past presentations. Essentially what happened was you had an employee who was sick, was off work for a while, was unable to return to work anytime soon. Okay, Costco eventually got fed up and said, look, we don't think you're ever going to come back to work. The contract is frustrated. The employee disagreed, sued for wrongful dismissal and a bunch of other things. And in this particular case, on the fact, the court said no. They agreed with the employee. They said, no, this contract has not yet been frustrated. Okay, so they basically looked at the medical evidence that was available at the time and decided that the employer had not discharged its burden of proof to show that the employee would not be able to return to work within the reasonably foreseeable future. Okay? Shortly after that, in 2011, we get a case called Frazier. Okay, the facts of this case are in many ways similar. You have an employee who was off work for a while. The employer eventually said, well, I think this contract has been frustrated. Okay, but this time the court agreed with the employer and said, yes, we don't think this employee is likely to ever be able to return to work again in the reasonably foreseeable future. Okay, so the court found in favor of the employer. Okay, so these two cases, I think, really show that the frustration analysis is highly fact-driven, okay, because there are facts in both cases on both sides which suggest that, yes, the contract was frustrated, and no, maybe not quite, okay? While we're at this part of the position, I do just want to highlight one quick quote in the previous case, Nacarado. I talked earlier about this fourth factor about the employee's role and its relevance in frustration. So just maybe make a note of that very first quote on this slide here, where we're talking about the senior executive versus the employee with a lesser role. Okay, so that there actually is explicit support for that factor right here in the case law in Nakarado. Okay, so again, that's just the factor of the employee's role in the workplace as it relates to frustration. Okay, so this is a relatively resolved issue here about whether short-term and long-term disability benefits being offered by the employer, and whether that means effectively that the contract can never be frustrated. The answer is no. Okay, just many employers do offer short-term and long-term disability benefits as part of their benefits packages. And yes, what that does mean probably is that the employer has contemplated that there may be times throughout the employment relationship that the employee may not be able to work, okay, and they would be entitled to receive those benefits. But just because that is one of the benefits offered to an employee does not mean that now the employer has lost their right to ever say that the contract of employment has been frustrated. Okay, that's not really such a contentious issue now. It was some time ago, but not anymore. Okay, so now I want to get into briefly this estate of Christian and Trimba case. This again was the example where it was the employee, in fact, who alleged frustration of contract. Okay, so before we get into the facts, basically the strategy of the employee, or the estate of the employee in this case, okay, it was an example of an employee who had died. Okay, so because the employee had passed away, there was never going to be a common law notice period, right? Because there was literally zero chance that the employee was ever going to work again. But the estate's strategy in this case was to try and find a way to get the employee's termination and severance pay entitlements under the Act, because the employee had many, many years of service, and those amounts were somewhat significant. Okay? So the facts of this case, so on May 22nd of 2013, Mr. Drimba advised his employer that he had shingles and would be away for 6 months. Unfortunately, that was not the right diagnosis, because in June of 2013, he gets a terminal cancer diagnosis. Okay? In August of 2013, the employer confirms in writing that despite an upcoming asset sale of the company, Mr. Drimba's employment would continue until such time as he was able to return to work, at which point the employer would arrange to have an interview set up with the new employer. But that never happened, because sadly Mr. Drimba passes away on September 17th of 2013. Okay, so what the estate argued in this case was that at some point after the terminal diagnosis, but before Mr. Drimba's death, the employment contract had been frustrated. That was the employee's argument, the estate's argument. Okay, so that argument is summarized here on this slide. Okay, and the court actually, in this case, did agree with the employee. So even though it was a bit unusual to have the employee be the one, or the estate in this case, to allege frustration, the court looked at the test for frustration and said, yes, even though the employer was promising, job interviews with the new entity and whatnot, and there was always an intention that, he was welcome to come back to work, even though that's what the employer was saying, the reality was simply that he was never coming back. Okay? So in this case, the court did decide that Mr. Drimba's estate was entitled to the termination pay and severance pay entitlements. And this case, the reasoning in this case has been subsequently cited and has been supported thereafter by judges. Okay? Now, the more complicated question would be, what if Mr. Drimba had simply passed away in the absence of a terminal diagnosis? Okay? So, based on what is or isn't in the Employment Standards Act and the common law right now, the answer right now probably is that there wouldn't really be any entitlement for him, but I just wonder if that reasoning would be consistent with the principles of frustration, and I would suggest to you that perhaps at some point in the near future, the courts may have to grapple with this question of, what happens if an employee passes away and, now can't work. Well, wouldn't that be frustration? Clearly the contract can no longer be performed. So that question, I would put to you as an open question, and the courts may need to weigh in on that one at some point, okay? So now we get into the 2018 decision of Roskaft and RONA Inc. It's another frustration case, same sort of idea as Nacarado and Frazier. Okay, the one thing that I'll just highlight before getting into the facts of this case in some detail is that the court made some comments about what they call post-termination evidence. So basically medical evidence that came to light after the employee was terminated. Okay, so we'll discuss that shortly. So in this case, we had an employee who was employed for 10 years in a clerical position prior to going on a disability leave. Short-term and long-term disability benefits were provided through an external insurance carrier. Approximately 2 years after going on disability leave, the employee completed a return to work form which indicated that he was unable to work and that the return date was not applicable. Soon after, the employer was advised by the insurer that the employee was totally disabled in relation to his own occupation and any occupation. And so approximately 9 months later, the employer picks up the file, reviews the letter from the insurer, and without any documentation, any other documentation indicating to the contrary, decides that this employee is permanently, totally disabled from any occupation, terminates him, and says that it's because the contract has been frustrated, okay? The employee disputes this. So in court, the employer says, well, look, we reasonably relied on the insurer's determination about the permanent and total disability, and were therefore not required to ask the employee for any further information. So, we're pretty sure that we're right here. The employee says, well, but I worked in a non-essential clerical position. I went on disability because I was hurt at work. There was some ambiguity as to if or when I was able to come to work. And the reason why I didn't submit any medical documentation around the time of termination was because no one asked me to. So I didn't. All right? So the court looks at everything, and the court agrees with the employer and does find that the contract was frustrated. But we look at the interesting issue in this case was what the court said about post-termination evidence. So in the employee's later submissions to the insurer for LTD benefits up to 1 year and 5 months post-termination, the employee told the LTD carrier that his current medical condition had not improved. So one of the issues the court had to deal with was, well, what use can we make of that evidence? Because this medical evidence came up after the date on which the employee was terminated, and it's fairly well established that if it's the employer alleging frustration, they have to rely on the medical evidence at the time of the termination. Okay? But the court essentially says, well, yes, we still are going to go by that principle, but if the post-termination evidence is relevant to what the employee's medical condition was at the time of the termination, well, then it's fair game and we can rely on it. Okay, so the court says, well, look, knowing that the employee's medical condition hadn't improved since the last update, well, I think that's pretty clear that probably at the time of the termination, a year and a half ago, that the employee was still probably not coming back to work in the reasonably foreseeable future. So the employer did permit the employer to rely on that evidence, and ultimately found that the contract had been frustrated. Okay? All right, so let's conclude here with some recommendations and conclusions and whatnot. So, first of all, an employment contract may be frustrated upon the diagnosis of a terminal illness, or more specifically based on DRIMBA, at some point between the diagnosis of the terminal illness and at some point before the death. Okay? Secondly, a contract may be frustrated if an employee qualifies for LTD benefits after 2 years. If there is uncertainty about whether an employee is temporarily or permanently disabled as it relates to frustration of contract, you can seek additional medical evidence. It's probably also a good idea at that stage in the process to get some legal advice to help you as an employer see what medical evidence you have, help you interpret the medical evidence that you have, and if we do need to get more, then to assist you in that process and communicating with the employee's doctors, making sure you have the right authorizations if you don't already, and so on. It's also important for employers to communicate with the insurance carrier so that they're in the know as to whether short-term or long-term disability benefits are being maintained or have been terminated. And then always, if you're terminating employees, in particular if you're dealing with a fact-based situation involving disability and you think you want to terminate the contract and allege frustration, it is a really good idea to get some legal advice about what your rights are and what your exposure might be. So that concludes my presentation, and back to Larry now to wrap things up. Thank you.